Hi, good afternoon, everybody. A very warm welcome to this afternoon's construction and engineering webinar brought to you by Burkitt Solicitors. And thank you very much for joining us for this, which is our autumn update. My name is Stefan Harris-Wright. I'm a partner in the firm and I head up our construction and engineering team. I'm based primarily in our Cambridge office. So I'm joined this morning by several of my construction colleagues from across some of our offices. So just to introduce you to them briefly now. So I've got my partner, Sarah Evans, who's based in our London office, and she leads on the construction team's dispute resolution work. Also joined by a colleague, James McLellan. James is an associate based in Norwich. James also focuses primarily on contentious and dispute-related work. And to complete the set of dispute-related construction lawyers, also joined by our colleague Rachel Lee. Rachel's a solicitor based primarily in Ipswich. So hopefully most of you have heard of Burkitt's before, but just in case you haven't, there's a little bit of information for you at a glance up on the slide here. I won't go through this in detail, but just in sort of summary terms, we're a full service top 50 UK law firm. We've got 7 offices across the UK in the east of England, London, Kent and Bristol. And as part of our firm, we've got a specialist team of construction and engineering lawyers, and we deal with both transactional non-contentious matters, but also project advisory and contentious related matters on construction projects when things get a little bit spicy later on, as they sometimes do. Right, so in terms of just a brief kind of summary of what it is we're going to cover during this afternoon session. So Sarah's going to talk us through the do's and don'ts of termination on contracts. James is going to give us a bit of a practical guide on matters relating to legal professional privilege. And then Rachel's going to finish things off with our usual sort of update on interesting recent construction and engineering cases. And then we'll have some time at the end for a Q&A with the panel. So before we get into the sort of meat of the session, just a few sort of bits of housekeeping for you. There's an opportunity for you to send in your questions using the Q&A function on the Teams platform. So please do let us know if you've got any questions you'd like me to put to the panel. We have had some questions in advance as well from delegates, which is great. So thank you for those. We'll do our best to get through as many questions as we can in the time available. And then I'll look to draw proceedings to a close, hopefully promptly, at the advertised time of 1:30. And then finally, the session is being recorded and will be circulated to delegates afterwards as a slide pack and a recording. So you'll get those in the coming days. So I will now hand you over to Sarah for the first main part of the session.
Thank you, Stefan, and thank you everyone for joining us this afternoon. As Stefan mentioned, I'm a partner in the London office of our construction and engineering team, and my focus is on helping clients avoid disputes, and also when they get into a dispute situation, helping them resolve them in the most cost-effective and efficient manner. So today, with a nod to the start of the rugby season, as you can see here, we're turning our attention to what happens when relations between players in the construction industry break down. What are some of the key issues and what do we need to be wary about? And I'm going to kick off by looking at that ultimate action of kicking a relationship into touch, termination. And I'm going to be flagging some of the do's and don'ts of the process. So first of all, it's important to remember that termination is an action of last resort. It's a really draconian and nuclear action, and it's likely to cause anxiety and risk, whether you're on the terminating side or the side being terminated. It's rarely straightforward. It's tricky and it's risky, and it's really important that you don't end up on the wrong side of the referee when you're doing it. Quite often we find ourselves in a situation where we get a call from clients, it may be late on a Friday afternoon, tensions are running high and relations are breaking down, and quick action is needed. but it's really important to get this process right. If you're the terminating party, if you're an employer terminating a contractor, and you get it wrong, then you yourself could find yourself on the other side of a claim for repudiatory breach and a claim for substantial damages, even including a loss of the contractor's profit on the matter. Equally, if you're the party being terminated and you don't play by the rules and get things right, then you can find yourself in a much worse position than you would otherwise need to be. So I think it's fair to say that this is an area where disputes are rife, and hopefully today will give you a flavour of the things that we need to be looking out for and the processes to be followed. So how do we go about terminating? Well, it's not easy, and there's only limited ways to do it. First of all, by agreement. Secondly, pursuant to the terms of the contract. And finally, at common law. Turning first to the first one, by agreement, this is an agreement on commercial terms. And we usually do this by recording the agreement to terminate in a formal settlement agreement. That minimises the scope for further disputes. This is the amicable divorce. This is the early conclusion. It leads to no arguments over procedural irregularities, and there's no risk of the referee's whistle. Secondly, pursuant to the terms of the contract, and I'm going to come back to this in a bit more detail at the moment, I think it's fair to say that parties spend a lot of time at the beginning negotiating, agreeing, and signing the contract. And then quite often that contract is put away. It may be put on a file on a shelf. It may be put in an electronic file, and it's forgotten about. But it's really important to remember that this is the rule book. This sets out the path, the rules that need to be followed. So it's really important to get that contract out, dust it off, have a look at it, and read it from cover to cover. We often use the term RTC, read the contract. Some people bluntly put an adjective in there, read the contract. I'm not going to do it today in case the referee is listening, but that's the code that we go past. In terms of the last area, common law, the common law provides for the repudiation of a contract where there is a fundamental breach. And when we talk about fundamental breach here, it's a breach that goes to the whole root of the contract. But great care is needed to do it under common law. So as I mentioned, let's have a closer look at terminating pursuant to the rules of the contract. Now here, termination is going to depend upon the precise terms of the contract that you've got, and every contract will vary. First of all, some contracts provide for termination at will. And that's termination which you can carry out without giving any reasons. It's important to notice here that the JCT standard contracts don't allow for termination at will unless you amend them. And in the case of NEC4, the employer or the client will only be able to terminate for no reason if it's chosen that secondary option X11. The beauty of termination at will clauses is they take effect quickly. They limit the sums that the terminated party can recover, and they're often therefore really useful for employers, not so useful for contractors and subcontractors. So if you're a contractor or a subcontractor facing at the start of the contract a clause that sets out for termination at will, you may want to get that taken out completely. And if you can't get it taken out, our advice would be to negotiate the longest notice period possible. So if it happens, you can get yourself organized, you can move on to other projects, and you can minimize your losses. Turning next to the areas for termination under the contract for breach, we'll start off with termination by the employer for contractor default. And one point that it's important to recognise here is when we're talking about termination, we're not talking about terminating the whole contract. We're talking about terminating the contractor's employment under the contract. So even if you terminate on this basis, there are going to be some provisions of the contract that still stay live and that survive termination. So in what sort of examples can an employer terminate for contractor to default? Well, first of all, if the contractor suspends without cause or abandons the works. If there's a lack of progress, and here we're generally talking about a failure to proceed regularly and diligently, or a failure to proceed with due diligence. And I'm going to come back to this one in a bit more detail in a minute. There can also be termination where a contractor fails or refuses to comply with an instruction to remove works, where goods are not in accordance with the contract, and if there's a failure to remedy defects. And other examples, situations such as the contractor not following CDM regulations or a contractor failing to provide security. If we switch it to the other side and look at termination by the contractor where there's been employer default, the sort of examples here are where the employer has failed to pay by the final date for payment. If the employer interferes in some way, such as if it interferes with an issue of a certificate, again, if it doesn't comply with CDM regulations, and also if works are suspended for a continuous specified period due to the architect's or the employer's instruction or act of prevention. And finally, under the contract, there are quite often provisions which allow either party to terminate. These include insolvency, force majeure, civil commotion or terrorism. And just popping back to insolvency for a minute, the definition of insolvency will be prescribed according to what the contract says. But you can't view this in isolation. The Corporate Insolvency and Governance Act popped on our radar during COVID, but actually it has hung around since. And what that means is that employers are largely unaffected, but a contractor may find that even if it has got a provision in its contract allowing it to terminate upwards for upstream insolvency, it may find it's unable to do that because SEGA prevents the contractor or the subcontractor from collapsing the supply chain in that way. So worth looking out for. And finally, when we've got grounds for termination, it's really important that we don't lose that ground. We must be really careful not to do anything to accept or to affirm the breach. Otherwise, you could face the referee's whistle and end up having to start that process all over again to establish your ground for termination. So let's just have a look at that closer ground that I mentioned under the contract. And this is the circumstance where an employer can terminate where there is a contractor failure to proceed regularly and diligently with the works. This provision is in both the JCT standard and the design and build contract. But there's actually no express definition in the contract of what this actually means. The courts have had a stab at trying to define it. And in the case of West Faulkner, the court tried to define it by saying that a failure to proceed regularly and diligently is an inability to proceed continuously, industriously, and efficiently with appropriate physical resources so as to progress the work steadily towards completion, substantially in accordance with the contractual requirements as to time, sequence, and quality of works. Well, I'm not really sure that takes us much further. It's not particularly clear. And any guesses how the court went on to try and set this out a little bit more clearly? Well, rather unhelpfully, they said it's a bit like an elephant. You know it when you see it. So it's going to depend on the facts of each case. It's going to depend on records. But generally, a contracted delay is not going to be enough to get you home on this one. But it may suggest further investigations may be helpful. If you've got some evidence of a failure to proceed in accordance with the programme productivity, or a failure to resource in a particular way, that again may help you. But again, the key here is records. And ultimately, just remember, the ref's interpretation of what this means may not be the same as what you think it is. So let's move on to the how. How do you go about terminating? Well, I've put here, follow contractual notice procedures to the letter. And really, if the contract tells you to serve a notice on pink paper, hopping on one leg, then make sure you do it. You've absolutely got to do it according to the prescribed procedure. And we need to look at various things here. The form of the notice. Check the contract, because it quite often has special termination notice provisions which differ from the usual notice provisions in the contract. Usually the form has to be in writing, but again, check this. In terms of the content of the notice, we suggest you always clearly mark it as a termination notice. And it's really useful to be able to quote the contract clause or the ground that you're relying on. The timing of a notice, again, defined in the contract. Quite often, there's a two-notice process. The first notice, a default notice, or what we often call a hurry-up notice, meaning that you need to serve the notice and giving it a prescribed period for that default to be remedied. And secondly, that second notice to be served after the prescribed time if the default hasn't been remedied. And also check when it's effective, because quite often deemed service, when that notice is deemed served, is not the same time as the point at which you post it. Quite often the deemed service can be 2 days after posting. So for an employer, make sure you don't boot the contractor off until the notice has actually bitten. And in terms of who serves the notice, well, again, contracts vary. Under the JCT Standard Building Contract 2016, the architect or the contract administrator serves the first one, and it's down to the employer to serve the second one. In the DMB 2016, it's the employer or the employer's agent who serves both. And again, how you go about it. Don't assume in this world of email that email is going to be permitted. It quite often isn't. The JCT 2016 versions, unless amended, prescribed for service by hand or by special delivery or signed for post. And always make sure you serve it on the address and on the persons prescribed by the contract. So we've looked at the what and how. What about the final do's and don'ts? Well, first of all, it's a risky process. Don't ignore the alternatives to termination. Given the risks, is there a better way? For contractor default, can the employer suspend instead? If there are delay and performance issues, then maybe the employer is better to consider liquidated damages or performance damages. And there may also be some available security to protect the employer. For the contractor, given the risks, is there a way to get to that outstanding payment instead? Maybe through adjudication, worth thinking about. And secondly, do consider the consequences of termination. It's really important to look ahead and plan what happens next. If it's the employer terminating, it will want to get those works completed after termination by another contractor. So who's going to do it? And does the employer need any further information before terminating to enable that to happen? And another thing we're thinking about is the final position. There are different financial consequences under the contracts. So it's always really important to get that financial status information right before terminating so you can consider the consequences. And as we've said, do prepare well, do collate your evidence, and do follow that contractual procedure to the letter. And finally, don't, once you've got that right to terminate, lose it. Don't sit back on the breach, don't dawdle. And above all, if you find yourself in that termination position, on whatever side, It's really important to take early legal advice. You may say, of course, I'm going to say that, but it really is. There's so much to get right here to ensure that termination gets you to where you really want to be. And ultimately, you want to be clapped off that pitch by your enthusiastic supporters for doing it right. So thanks very much for listening to me on that. I'm going to hand over now to James, who's going to touch on the issue of privilege and why, when relationships break down, it's really important for us to know how that can help us.
Thanks, Sarah, and thanks everyone for joining. As mentioned, my name's James McLellan, and today I will be providing a practical guide to legal professional privilege. Now, the obvious place to start is with an explanation of what privilege is. In short, privilege provides a legal right to withhold evidence from inspection by a third party or court. Now, in practice, where a relationship breaks down and privilege is used properly, it can be key in ensuring a secure environment for discussion and the formulation of legal positions, and provide you with an environment in which to obtain legal advice from the outset. Legal professional privilege, the subject of this talk, is a particular form of privilege. You may have heard of other kinds, such as without prejudice privilege and common interest privilege, but legal professional privilege relates to communications dealing with parties' legal positions and legal disputes in particular. There are two forms of legal professional privilege. Those can arise simultaneously, but they're distinct. So those are legal advice privilege and litigation privilege. You'll see the requirements for both outlined on the accompanying slide, and I'll just run through those briefly now. So dealing with legal advice privilege first, our first requirement is that it relates to communications which are confidential. This is generally a fact-specific question based on the availability and nature of the communication. So certain financial information could be confidential in the context of, say, negotiations over a merger, but it's less likely to be confidential where it has been published and is, say, publicly available in a company's yearly accounts. Second requirement, communications between a lawyer and their client. Now, what constitutes a lawyer is generally quite broad. So the definition covers individuals qualified as solicitors, barristers, or legal executives. However, the definition of a client, the courts have adopted a very restrictive view of. So a client is interpreted as those individuals within a client organization who are actually charged with instructing the relevant lawyers. This is termed a client team. And this issue in legal advice privilege is a substantial point which we will return to in this presentation. Now, the third requirement, that the communication be for the purposes of giving or receiving legal advice. Now, the communication must come into existence for this purpose. So by way of example, a request for advice could be privileged, but a historic background document probably would not be. So moving on to litigation privilege, you'll see the three requirements again. The first requirement being that the communication be confidential, much like legal advice privilege. However, the second requirement, that the communication be between a lawyer, a client, or a third party. You'll note that litigation privilege may apply in respect of communications with a third party. So unlike legal advice privilege, you're not limited to communications with the client team only. And the third requirement, that the communication be for the dominant purpose of litigation, which is pending, reasonably contemplated, or existing. Breaking this up slightly, so the question of a dominant purpose is considered based on the state of mind of the commissioner of the communication, so generally the client. The need for a dominant purpose means a document doesn't benefit from litigation privilege where you have two equal and competing purposes. And finally, as to pending or reasonably contemplated litigation, there's a requirement that litigation be a real likelihood. That doesn't mean that there needs to be in excess of a 50% chance. And a good way of conceptualizing this is thinking, is there a good chance that litigation may happen, as opposed to that it will or even is very likely to. So the key takeaways on defining the forms of legal advice privilege: we have two forms. They can arise simultaneously, but generally legal advice privilege we would expect to arise earlier in a matter, given that litigation privilege requires at least the prospect of litigation in future. So now we understand the nature of privilege, let's consider the threats parties should be aware of, i.e. the circumstances in which you may be required to produce documents for inspection. In construction disputes, the three most likely fora in which document inspection may be required are adjudication, litigation, and arbitration. Now, dealing with these in turn, adjudication does not have a formal disclosure process, but adjudicators are empowered to order production of relevant documents by parties. In litigation, parties will be expected to disclose with initial statements of case the documents they're relying upon or are needed to understand their positions. Thereafter, in litigation, a process of extended disclosure can be chosen from 5 different available models, and that decision is generally made on the basis of proportionality to the sums and the issues in dispute. Now, arbitration is a consensual process. It's dependent on the agreement of the parties, and so the parties can agree on the institutional rules and the disclosure regime they want to apply. A tribunal, however, generally does have a discretion to determine the particularities of that process and to order production of documents. How this operates in practice is that parties are usually expected to produce the documents they rely upon and are able to request documents from the counterparty where they're relevant and material to issues in dispute. I would also note, however, that disclosure and inspection is not limited to formal disputes. Parties can be ordered to produce documents in investigations by, say, the police or the tax and regulatory authorities. So privilege can provide protection outside a formal dispute setting. So, key takeaway here, parties have obligations to disclose potentially adverse documents within and outside of formal dispute settings. But when used properly, privilege can substantially reduce the extent of risk that arises from these obligations and can help put parties on the front foot from the outset of, say, a relationship breakdown. Now, the rules surrounding privilege can feel very abstract, and so it helps to provide a practical example. In this case, we have an employer party, Twickenham Limited, which is dissatisfied with its contractor and has requested advice on its position. There's a number of stages of information requiring which will be necessary in obtaining that advice, and I've outlined those. Before we consider those in detail, we have to think which form of legal advice privilege do we think applies. That's something of an impossible question because the answer depends on Twickenham's own understanding of its position. Is litigation pending, reasonably contemplated or existing, and is any such litigation the dominant purpose of the advice? For the purposes of this presentation, we will say no. This is an advice purely as to liability under the contract, and we will consider this fact pattern from the perspective of legal advice privilege. So let's look at where things can go wrong and reliance on legal advice privilege can fall down. You'll see the first step, an initial briefing to lawyers. Fundamentally, this is fine, but I would note that Twickenham's legal team has instructed the lawyers here and provided the background. As such, they will be the client team for the purposes of legal advice privilege. Next, we have the provision of relevant documents. Clients often refer us to commercial colleagues for background factual information, and that has happened here. In the context of legal advice privilege, this is problematic where the client team is the internal legal team, but we're liaising with a commercial team, as the commercial team falls outside the bounds of the client team and their communications will not be privileged. I would also note for completeness that there is an issue in historic documents being provided, whether that be commercial or legal teams, in that historic documents won't necessarily have been produced for the purposes of obtaining legal advice and may not be privileged. Receipt of advice and initial consideration. Here, the advice has been received by the client team, but it has been circulated onwards and considered at a board meeting. Parties need to be aware of where the content of advice ends up. For example, board meetings are recorded in minutes which cannot be privileged, and so a degree of advice may be recorded in a non-privileged document. You'll see consultant involvement has been brought in here. Parties can involve external agents in instruction of lawyers, but it's important to remember that their communications are only privileged where they provide simply a medium of communication and don't have personal input. Next, we have a situation where a further instruction has been provided. It's common for clients to ask for guidance on the commercial impact of advice. However, the dominant purpose test, i.e. obtaining legal advice, needs to be borne in mind. Where advice ceases to focus on a legal position and instead a lawyer acts as more of a commercial advisor, such communications will cease to be privileged. And then finally, for completeness, parties should be aware of the use of advice documents going forwards and consider in knowledge share and financial reporting whether any advice is being incorporated into documents which might not be confidential or privileged in future. So that's where things can go wrong. How do we stay on side and maximize the likelihood of privilege attaching? Firstly, on confidentiality, it is fundamentally important to control the spread of documents and information. This can be via information barriers or more generally avoiding repeating advice. Where advice does need to be repeated and circulated, it can be provided subject to an express limited waiver of privilege, which maintains privilege against other third parties. In relation to lawyer and client communications, discussions with legal advisors should take place early. Damage to a party's position can be done from the outset where privilege is not borne in mind. We can assist from the outset with key points like establishing a client team, circulating documents on clients' behalf where necessary, or reviewing internal processes to ensure privilege is maximized. And finally, on dominant purpose, when corresponding, clients should always think about whether there is a clear dominant purpose to communications before preparing them. Avoid blurring boundaries and producing documents which deal with, say, legal advice and other considerations like financial impact to the extent that those can be separated out. If the potential for litigation arises, this should be recorded in writing as a clear reference point for the future. And finally, while not determinative, it is always advisable to clearly mark potentially privileged documents and correspondence as such as a matter of best practice and good document management. Right, well, we have reached the end of this discussion, which is intended as a broad and practical overview of the complex issue of legal professional privilege. I will now hand over to my colleague Rachel, who will give an overview of case law relevant to the issues of termination and privilege that Sarah and I have just discussed. Thank you.
Thank you, James, and good afternoon, everyone. As mentioned, my name is Rachel Lee, and I'm a solicitor in the construction team at Burkitt's, based in Ipswich. Today, I'm going to be discussing some cases relevant to both the themes of termination and privilege. Beginning with the termination cases then, the first one I'm going to be discussing is Optimus Build Limited and Southall. So in this case, the TCC dealt with a pretty familiar scenario, a breakdown between a contractor and employer mid-project, with both sides claiming that the other had committed a repudiatory breach. Optimus was engaged to carry out extensive works on a residential property, and the contract was informal, so there wasn't any signed JCT or bespoke agreement. Instead, the contract was based on a series of meetings and emails. Optimus believed it was a fixed price contract, whereas the homeowners thought it was cost plus. Now, the dispute kicked off after Optimus submitted its third interim valuation. The homeowners queried the figures and demanded a breakdown. A site meeting followed, which became heated, and Optimus suspended works and proposed a meeting to resolve the payment dispute. Now, the homeowners saw this as a threat of, to quote, holding a gun to their heads, and responded by telling Optimus to remove its equipment and that they'd be making alternative arrangements. Each side accused the other of repudiation. Optimus said that the homeowners had thrown them off-site, and the homeowners said that Optimus had walked away first. So Optimus issued a Part 7 claim in the TCC seeking damages for breach of contract and loss of profit. The court were then tasked with deciding what was the contractual basis, fixed price or cost plus, and who committed the repudiatory breach. So in terms of the contractual basis question, the judge found that the contract was fixed price, not cost plus. It was found that the employer's acceptance of Optimus's budget estimate had given rise to a lump sum pricing structure, and the estimate had been provided in response to a request for a lump sum quotation and referred to price, not estimated costs, and there wasn't any reference to markup or overhead profit. As for who committed the repudiatory breach, the court found that Optimus's suspension of works was not repudiatory. It was conditional and aimed at resolving the dispute. In fact, the homeowner's actions of seeking alternative contractors and demanding removal of scaffolding amounted to repudiation, which Optimus validly accepted. So Optimus was awarded the balance of the contract price and loss of profit on the remaining works. In coming to its decision, the court applied the test for repudiatory breach, which is whether the conduct showed an intention not to be bound by the contract. The judge emphasised that a contractor pausing works due to non-payment is not automatically a repudiation. The homeowner's reaction was disproportionate and amounted to a premature termination, and the contractor's conduct must be assessed in context. So here, Optimus had made some efforts to resolve the dispute and resume works. In terms of some key takeaways of the case, repudiation is clearly a very serious allegation, and it must clearly show an intention not to perform. Termination for repudiation is very high risk, bit like a drop goal from halfway, a la World Cup final 2003, miss and you could lose the match. Suspending works for non-payment can be valid, but it must be clear and proportionate. Jumping the gun on termination can backfire. You might end up being the one that's in breach. So it's important to always check the contract before suspending or terminating, as justification is really key, and communication counts. A well-worded email could be the difference between repudiation and resolution. So turning to Manor Co-Living and RY Construction now, this is a case that further highlights the risks of going for a try without checking that you're still in play. So the dispute here arose under a JCT Design and Build contract 2016. RY Construction was appointed to convert a former office building into residential accommodation. Manor Co-Living, the employer, became frustrated with delays and alleged poor performance and decided to terminate the contract, not under the JCT's termination provisions, but by alleging repudiatory breach at common law. In the round of adjudication that followed, the adjudicator found that RY Construction had not repudiated the contract, that Manor's termination was wrongful, and RY was entitled to damages for breach. Now, Manor obviously didn't accept this decision and issued a Part 8 claim in the TCC, seeking declaratory relief that its termination was valid and that RY had been in repudiatory breach. So RY responded with a counterclaim for damages. In the TCC proceedings, the court found that RY Construction had not abandoned the site. It found that RY had paused works due to Manor's failure to make timely payments under the contract. Specifically, Manor had failed to pay certified sums, which left RY without the cash flow needed to continue works. And this wasn't deemed as a refusal to perform, but rather a commercially justified suspension, so a response to breach, not a breach in itself. The judge noted that RY had made efforts to engage with Manor and resume works once payment issues were resolved. There was no evidence of an intention to abandon the project or walk away from contractual obligations. Manor's termination letter did not comply with the JCT contract, and its attempt to terminate at common law was deemed to be unjustified. The court found that Manor had failed to establish that RY's conduct amounted to a repudiatory breach. Instead, Manor's actions, terminating without proper basis and failing to follow the contract's termination procedure, amounted to a repudiatory breach, which RY validly accepted. So RY was awarded damages for loss of profit and costs incurred, a costly own goal for Manor indeed. So in terms of some key takeaways of the case, in the decision, the judge emphasised that termination at common law is a drastic remedy and must be based on clear evidence of a serious breach and not caused by your own conduct. Courts are going to be looking at full context, including reasons for delay or suspension. And it's also vital to always check whether the contract provides a termination route and make sure you stick to it. Contractual termination provisions must be followed, especially under standard forms like the JCT, and skipping them can invalidate your termination. If you go rogue, you risk being penalised for a high tackle. So now turning to the theme of privilege, the first case I'm going to be discussing is Three Rivers DC and Bank of England number 5, also known as the Three Rivers number 5 case. This is a landmark decision that continues to shape how we understand legal advice privilege. So this case arose out of the collapse of BCCI and the subsequent Bingham inquiry. The Bank of England had appointed a small internal team, the Bingham Inquiry Unit, to liaise with its lawyers and prepare submissions. The bank claimed legal advice privilege over a wide range of internal documents prepared by employees and ex-employees, arguing that they were created for the purpose of obtaining legal advice. In its decision, the Court of Appeal took a restrictive view and held that legal advice privilege will only protect communications between a lawyer and their client, and that in a corporate context, the client isn't the company as a whole, but a narrow group of individuals specifically tasked with seeking and receiving legal advice. Communications from other employees, even if they were used to inform legal advice, were not deemed to be privileged. So this decision has had significant practical consequences and means that internal documents prepared by employees, even if they're intended to support legal advice, may be disclosable unless the employee is part of the designated client group. It does not extend to communications with third parties or internal documents prepared by employees outside the designated client group. And just to point out a quick distinction, there's also another case, which is the Three Rivers number 6 case, which went to the House of Lords at the time. And the number 6 case focused on what type of documents are privileged, and confirmed that lawyers' internal working papers may be privileged even if they're not shared with the client. So going back to number 5, since then, courts have really criticised this approach. In Director of the Serious Fraud Office and Eurasian Natural Resources Corporation, the Court of Appeal made it clear that if it had been open to them to depart from Three Rivers number 5, then they would have been in favour of doing so. However, this is a matter that would have to be considered again by the Supreme Court. Similarly, in Civil Aviation Authority and Jet2, the Court of Appeal considered that the foundation of the judgment in Three Rivers, namely an analysis of 19th century authorities, was unsafe because those cases were decided at a time when the distinction between litigation privilege and legal advice privilege was very much in its infancy. The court added that the difficulty with Three Rivers is that it doesn't recognise that in the present age, companies can be extremely vast and multinational, and that information on which legal advice is sought may not only be in the hands of instructing lawyers. So it's possible the Supreme Court may revisit this case, but for now, best to play it safe, define your client group early and control the circulation of information. So in terms of some key takeaways of the case narrowed the definition of client for legal advice privilege. Not every player on the pitch is protected. Clients should carefully consider who is authorised to seek legal advice and document this clearly, ideally at the outset of a transaction or investigation, and then consider creating a record that can be updated as the matter progresses of who constitutes the client for privilege purposes. However, be mindful of the risk of waiving that privilege. And the case isn't without controversy, as we've seen the Court of Appeal has strongly criticised the decision in later cases and made clear it would depart from the decision if it had been free to do so. Communications from employees outside the client group may be disclosable unless covered by litigation privilege, which in comparison can offer broader protection, but only if the dominant purpose is litigation. So very important to channel legal advice through the designated client group or in-house legal team, but to be cautious about assuming that privilege is going to apply to every single internal communication. So finally, and hopefully quite quickly, I'm just going to discuss the Jardine Strategic Holdings and Oasis Investments case. This is a very recent landmark decision from the Judicial Committee of the Privy Council, the JCPC, that has reshaped the law on legal advice privilege in shareholder disputes. So this case arose from a corporate restructuring within the Jardine Matheson Group. In 2021, Jardine Strategic Holdings was amalgamated with JMH Bermuda Limited, and minority shareholders who were unhappy with the offered price of $33 per share brought appraisal proceedings under Bermuda's Companies Act, seeking a judicial determination of fair value. So as part of those proceedings, the shareholders sought disclosure of legal advice obtained by the company before the amalgamation, and they relied on the shareholder rule, which is a very long-standing principle that allowed shareholders to access privileged legal advice, which is paid for out of company funds, unless the litigation was hostile. So the key legal issue to be decided in this case was, could the company assert legal advice privilege against its own shareholders in litigation, or did the shareholder rule override that protection? So the JCPC in its decision abolished the shareholder rule, and it held that the idea that shareholders have a proprietary interest in company assets, including legal advice, is outdated and inconsistent with modern company law, that there's no sufficient joint interest between company and shareholder to justify overriding that privilege, and that legal advice must remain confidential to ensure directors and management can act in the company's best interests. In a rather memorable line, the JCPC said, like the emperor wearing no clothes in the folktale, it is time to recognise and declare that the shareholder rule is altogether unclothed. So as a result of the case, companies can now assert legal advice privilege against shareholders in litigation, even if the advice was obtained before the dispute arose, and reinforces the principle that legal advice is for the company, not its shareholders. And just finally, for some context, the JCPC is the final appellate court for many overseas territories. Normally, its decisions aren't binding on English courts. However, in this case, the JCPC issued what's known as a Willers and Joyce direction, stating that its decision should be treated as binding by courts in England and Wales. So the ruling will change English law, and the shareholder rules no more. This is a major win for corporate confidentiality and offers clarity in privilege law, which is now playing a tighter, more disciplined game as a result. So that's all from me. Thank you very much. And that will bring us on to the Q&A section of the webinar.
Good stuff. Thank you very much, Rachel, and to our other panelists for their sections of the presentation. We do have some time left for some questions, which is good news. And we've had a couple of questions come in on the live Q&A, so thank you for those, in addition to the ones we had in advance. So just having a look at these. There's a question about the Corporate Insolvency and Governance Act and retention, which sounds like it's probably quite fact specific. So it's probably best if we come back to you on that one afterwards, if that's okay, just to get a little bit more detail. But there's also a question about legal privilege. So James, probably one for you. So that's why would the client team be defined so tightly to exclude the commercial team in the example given? Would it not make sense to define it at the outset to include any employee of the client?
Sure. So, I mean, that there's a few points raised there. Firstly, why is the client team defined tightly? That is fundamentally an expectation of the case law. Rachel referred to the Three Rivers decision there, which places quite strict boundaries around the client team. Now, the example provided of a legal team being the client team and a commercial team being outside of that was in a way kind of an extreme example given to demonstrate the principle. You could ultimately define a client team to include someone from the commercial team to help the flow of information, but you would, I think, struggle in any company of a reasonably large size to include all employees. There's a need when defining a client team to ensure that you're not artificially trying to maximize privilege, because there's ultimately, if that's then challenged, there's a risk that it's disapplied and the communications are, end up being unprivileged. So you can tailor your client team to best suit your requirements in a matter, and if you need information shared across commercial and legal teams, you can establish a client team accordingly. But there's one other point I would mention is that even if you have someone in the commercial team, that doesn't, there's still, pervasive privilege issues you'll need to consider, because if you have an individual from the commercial team, they may not know everything, all the background information that needs to be considered in order to provide advice. They may need to liaise with other members of the commercial team who would still fall outside the definition of a client team, and their communications with the rest of the commercial team would be outside the client team and would not benefit from legal advice privilege. So I think that's a very long way of saying it's very complicated. There are things you can do to help the flow of information, but it's something of a constant battle and something you need to stay on top of and consider and manage over the course of a matter.
Good stuff. Thank you, James. Sarah, if I come to you next, question that we had in advance was around points you were discussing on termination. So you mentioned termination. So in circumstances where the whole contract doesn't fall away and some clauses survive, what are the usual clauses to continue in that circumstance?
Okay, thank you. I think it goes back to that acronym RTC or RTC. It's about going back and reading your contract and seeing what it says, because again, the standard forms prescribe this, but there may be amendments to that, and other contracts may put in different provisions. But generally, the sort of clauses that will survive are all the things around notices. So I spoke before about there's general notice provisions and there's termination ones. So that those notice provisions will usually stay in play. Other areas like dispute resolution provisions, whether that's adjudication, arbitration, litigation, that will still stay in play. Rights accrued up to the point of termination remain enforceable. So you're still going to have your rights in relation to claims for breach of contract or defective works. And other areas like warranties and guarantees that have been provided and that apply, they will still remain. And also indemnity clauses often or usually remain, because that gives protection even after termination. So that's a bit of a flavour, but again, it comes down to the specifics of each contract.
Great, thank you, Sarah. Rachel, if I come to you next, question about the Jardine decision, and also the query really is, how does that affect privilege in shareholder activism or hostile takeovers?
Ooh, interesting. I must admit, when I first read the judgment for this case, my own personal view was this feels like the court wants to send a message to activist shareholders here. I mean, previously, under the shareholder rule, shareholders could argue for access to privileged legal advice paid for by the company, especially in non-hostile contexts. But this, of course, creates some uncertainty in disputes involving minority shareholders or any activism. So I suppose by abolishing the shareholder rule, the JCPC is asserting that legal advice privilege belongs to the company and it can't be overridden by any shareholder interests. So yeah, any activist campaigns or shareholders, they can have legal advice withheld from them, which protects strategic communications, internal deliberations. So the case demonstrates a major shift, really, that aligns privileged law with modern corporate governance and the autonomy that boards have.
Okay, thank you, Rachel. James, there was another question about defining the client team, but I think you probably covered that off in the first one. So there's one here around communications for the purposes of giving and receiving legal advice, and what counts as legal advice in that situation.
Sure. So, this, like lots of issues with privilege, it's a fact-specific question, but generally the definition of legal advice is very broad, and it kind of covers advice relating to and dealing with parties' positions under issues of private or public law. So in terms of definition of legal advice, that's a broad definition which will, capture lots of issues. I think the main, it's good to be conscious of it, but I think the main issue in terms of legal advice privilege, or the one that parties are more likely to be tripped up by, is the client team definition.
Okay, thank you. I think we've got time for two more quickly. So if I come back to Sarah first, Sarah, which is better, terminating at common law or terminating under the contract?
Ooh. Again, I think what's going to be better is going to depend on every single different circumstance. It's going to be a case of looking at the facts, looking at the position you're in, looking at your contracts again on that, and also what records you've got to prove whatever you're going to do. Generally, I suppose contractual termination, you've got your rule book. You've got that rule book when you look at it that sets out what you can do, how you go about doing it. So that's a little bit more prescriptive and possibly sometimes easier to follow. Again, you've got to be careful you don't get caught out by the notice provisions on that and you do it right. The common law approach can sometimes be quicker. But again, you've got to be able to prove that fundamental, that repudiatory breach, that breach going to the root. And that is not always easy. And sometimes, depending on the ground that you've got, for example, if you wanted to terminate for insolvency, there isn't a general law, a general provision under common law for you to terminate for insolvency, which would then send you the other way to the contractual route. So I think it's horses for courses. You've got to assess on each one and then look at what's the best option according to that.
Okay, thank you. Rach, last one for you, and then I'll draw proceedings to a close. And the question is whether a party can rely on common law termination if the contract provides a termination mechanism.
I feel like this is going to probably echo quite a bit of what Sarah has covered here. Generally, no. I mean, the courts expect you to follow the termination provisions that are going to be set out in the contract before resorting to common law rights. And thinking about the Manor co-living case, Manor ignored their JCT termination procedure and tried to rely on common law repudiation, and the court the TCC just sort of rinsed them for this, really. Like the common law argument didn't really get off the ground because the fact that they hadn't even attempted to comply with the JCT procedure just took them nowhere. So takeaway, I suppose, is common law termination definitely is not a shortcut, it's the last resort. So yeah, take the contractual route if you can.
Good stuff. All right, thank you, Rachel. Right, okay, well, I think that's just about all we've got time for. I hope you found this afternoon's session useful and informative. As we mentioned at the start, the session's been recorded, and that will come through to you in the coming days. And at the same time, there's an opportunity for you to provide us with any feedback that you have on the session. We're always very grateful to receive that. If you've got any thoughts on the session, and in particular whether there's any particular subject matter that you'd like us to cover in future webinars, please do let us know. Looking ahead, the next webinar we've got coming up is our winter edition. That's on the 19th of November. Invitations for that will come out through the usual channels to our subscribers and on LinkedIn and so on. So in the meantime, all that really remains for me to say is thank you very much again for joining us from myself and the panel.